Okay, well, welcome to all of our attendees to the Bridge to Independence program training. My name is Mary Pat Coe, and I'm from the Court Improvement Project. We are a federally funded program in all the states, and our goal is to improve court outcomes for kiddos in child welfare and youth justice cases through education, collaboration, and utilizing data. And today we have some experts with us to help us explain the expansion of the Bridge to Independence program to probation youth who will qualify coming this beginning of this next year in 2025. A few housekeeping things first. If you have any questions, please put them in the chat. If you are looking for CLE credit, put your name and your bar number in the chat, because as you know now, we have to report your attendance to the MCLE. Also, at the end of the program, we'll share the slide deck in the chat as well. And as I said, today we're lucky enough to have some experts in the B2i program with us. We have Sarah Helvey from Nebraska Appleseed, Deanna Breakage and Kathy Onstein from HHS, and Lindsay Meyer from Probation. And Tracy, if you can go to the next slide. Perfect. What we're going to cover today is the B2i background and history, some evaluation and data information, program overview, what the expansion to our probation youth looks like. That I'm sure a lot of you know that there is an appeal on LB 50. We'll touch base on that a little bit, and then some things to consider. So first off, we're going to hear from Sarah Helvey, who is going to go through kind of the B2i background and history, how it all started. Sarah?
Okay, great. Mary Pat, can y'all hear me?
Yes.
Okay, great. Hello, everyone. Thank you for joining us. So just to Tracy, could you move us to the next slide, please? Thanks. So just to level set a little bit, as I think we all know, when we say the Bridge to Independence program, or B2i, we are talking about Nebraska's extended foster care program, which allows youth to continue receiving foster care-like services and support until age 21. Before B2i, traditionally, youth could only be in foster care under the jurisdiction of the juvenile court until they reached the age of majority, or 19 in Nebraska. But there was a real need that we were seeing both locally and that was documented nationally to provide support for youth beyond age 19. And you can see there on this slide, there was some national data showing that young people who age out of foster care without achieving permanency, so without reunifying or being adopted or guardianshiped, of that population, less than 2% finished college, over 50% experienced homelessness, and others struggled with employment, healthcare access, and poverty. Nebraska at the time had the former award program, but there were a number to provide some assistance to young people who aged out. But there were a number of gaps in that program, namely that it was mainly focused on young people who attended college. So in recognition of that national data, in 2008, Congress passed the Fostering Connections to Success and Increasing Adoptions Act, which allowed states to draw down federal funding, Title 4E, to create programs to extend foster care services to age 21. The slide says that 58 states have extended programs. I think that's correct. But just to note, I think there are 20 states that, like Nebraska, have taken that federal option to get federal funding to extend foster care. Almost all the states have some sort of extended foster care, but some of them provide it with state-only dollars. Okay, next slide, please, Tracy. This just gives a little background, as Mary Pat flagged, on the process in Nebraska to establish this program back in 2013. It was established by a bill that was introduced by Senator Amanda McGill, LB 216. The process that went into that, I just want to emphasize, was really youth-driven. It's something that I'm super proud of us as a state for. There was a stakeholder group, a fiscal analysis. HHS provided a lot of data. There were surveys of over 250 stakeholders, and surveys and focus groups with over 100 young people. And then young people were involved literally in every aspect of the process. They gave feedback literally line by line on the language in the bill. They testified at the hearing, and you can see the picture on the slide. That's Jacob talking to Senator Crawford. They pulled senators off the floor and really advocated from the bill from start to finish. And I think if you look at our statute, a lot of that youth involvement is reflected in the way the bill is drafted. So you can see that the bill passed in 2013. Nebraska had to file a state plan amendment to get federal approval for the plan, and the program began on October 1st, 2014, so 10 years ago. And you can see citations for the regs there as well. Importantly, the original bill established a B2i advisory committee that sits under the Nebraska Children's Commission, and that advisory committee is tasked with advising and making recommendations to the legislature regarding the ongoing implementation of the program. As a result of that, there have been a number of cleanup bills and expansion bills, many of which we'll talk about today. I only have 2 on the slide, but then I went down a rabbit hole when I was preparing for this, and there are actually, I believe, 6 like cleanup follow-up bills. I am certain I testified on all of them, making, as I said, some cleanup, some expansions, even some narrowing of the program as it's been implemented, and in large part due to the feedback of the B2i advisory committee that does include young people as well. Next slide, please, Tracy. This one's a little bit duplicative. This just shows some of the purposes of the B2i program, and you can see they're in the statute to help young people transition to adulthood, become self-sufficient, and establish permanent relationships. That's an important part of it. We can jump to the next slide already. Tracy, please. Shifting to what I think is a big focus today, the most recent expansion of the program to include young people with juvenile justice experience. As we know, currently the program is only available to youth with child welfare or child welfare case or adjudication. But starting January 1st, it will be available to young people, specific subset of young people that we'll talk about with some juvenile justice experience. This is a result of LB 14, what was originally introduced as LB 14 by Senator Dungan in 2023, and eventually passed as part of a larger criminal justice package, LB 50. Once that expansion goes into effect here in a few weeks, it's estimated to benefit about 50 young people per year. That was what was estimated, I think, in the fiscal note, which is great. Before getting into the details of expansion, a couple of things to note. This expansion was a long time coming and a result of many years of work and advocacy. There have been actually a couple bills that were introduced to do it, I think by Senator Bowles and maybe Pansing Brooks before this eventually, and a couple of iterations before this eventually passed this in 2023 by Senator Dungan. Again, it's been a long time coming. The original bill, LB 216, that established the B2I Act, originally, the original version of that bill included young people with juvenile justice experience, but unfortunately, that population had to be amended out. It was a very difficult decision for 2 reasons. One was fiscal, of course, and the second was that was the same year when probation was for youth were shifted from HHS's responsibility to the judicial branch. And so that there were some other administrative changes going on at that time. But bringing that population back into this program was always the intent. And to that end, the B2I Act originally specifically tasked the B2I Advisory Committee with recommending ways to expand the program to other at-risk youth. And the committee consistently made that recommendation. And then hopefully it goes without saying to you all, but having both populations in the B2I program just makes a lot of sense. Not only is there a lot of cross-system involvement, but youth and young people who are duly adjudicated were always eligible for the B2I program as long as they had that 3A adjudication. But I think we saw a lot of gaps there, including that sometimes duly adjudicated young people, they would close the foster care case, and that in that circumstance, they would not be eligible for the B2I program. And both populations have high risks of experiencing the negative outcomes that I mentioned earlier. Both populations may not have supportive adults or environments or resources to help them with their transition into adulthood. And research has shown that extended foster care programs like B2i have been demonstrated to help improve outcomes for both populations. And then finally, they're really tiny at the bottom of the slide. I think it's always important to include the voices of youth front and center. And since many of them have worked for many years on this expansion, so that's just a quote. And then the person whose quote that is, her name is Kayla. The attribution dropped off the slide there, but that's just a quote about the importance of the program from Kayla, who is a young person that helped with advocacy and participated in the advisory committee. Next slide, please. We will, I think, share this out electronically after the presentation, but these are a couple of resources that Appleseed has created that I want to share with you on the left. Thank you. Or maybe we're going to put those in the chat. On the left we call it a bench guide, but it's really a legal one-pager. There's two versions of that. One for the lawyers and judges that has like all the statutory language and the statutory citations. And then one that's still legal focused, but more plain language, but still I think has the references that you need. And then on the right side, the colorful one, of course, is a youth for young people, a fact sheet for young people. So we encourage you to share that with your clients and young people that you may be working with about this expansion. Next slide, please. Okay. Just a few things to remember generally about the B2i program overall that I think can be misunderstood sometimes. The first is that the B2i program is voluntary. So youth, both JJ and Child Welfare Youth, are not obligated to stay in foster care after they turn 19. As adults, the juvenile court and HHS do not have authority over them anymore unless they opt into it. So they voluntarily choose to join B2i and they can voluntarily leave at any time. And in fact, that B2i Act is very clear. There's a quote there from 4502 about the autonomy of young people is to be respected and recognized at all times. However, even though it's voluntary, B2i is technically foster care. So if a young person does choose to participate, they are like voluntarily putting themselves into foster care. And at that point, the state once again has responsibility for them and for their well-being. Similarly, the juvenile court has jurisdiction over them, which includes ensuring their best interests are upheld through regular review hearings or other proceedings and decisions as necessary. Although the authority of the juvenile court in the B2i program is drafted pretty explicitly in terms of the juvenile court's ability to be helpful and I think not punitive. But there is juvenile court jurisdiction that they are voluntarily agreeing to be a part of through the B2i program. And then lastly, as part of being in the program, the Foster Care Review Office, this is a federal requirement, retains authority to review their case and make recommendations as if necessary. And then also to note, being in B2i is in foster care for the purposes of Medicaid benefit, meaning young people may have Medicaid eligibility while in B2i through either the Title 4E category, foster care eligibility category, and after they leave B2i through the former foster care category of Medicaid that allows young people to stay on extended Medicaid to age 26. And that was affirmed in 2018 in Nebraska Supreme Court case, our friend Azar Webb versus HHS, that was an Appleseed case. Next slide, please. And then another thing to note is, I guess, just sort of maybe an interesting dichotomy in B2i in terms of its terminology. While young people are legally adults, generally, for the purposes of Child Welfare Services, federal and state law define child as up until age 21 for the purposes of B2i. So it's sort of like this legal fiction that we create so that states can continue to provide child welfare services like B2i. And then lastly, An attorney's role in B2i, I think it's important to note, is different than in under 19 foster care. So as we know, in under 19 foster care, a GAL's role is to represent what they believe to be in the youth's best legal and best interests. But once they are in B2i, they are an adult. So it's up to them if they want an attorney appointed to represent them or not. If they do, the statute says that it can be the same attorney from their under 19 case or a different one. And whoever that is, because they're an adult, the role of the attorney becomes then changes from a best interest to a client-directed representation. Next slide. I think I am turning it over, but I'm coming back. Thanks, everyone.
Thanks, Sarah. I'm Deanna Breakage. I'm the program specialist with the Division of Children and Family Services over the Bridge to Independence. As Sarah indicated, this is our 10th year anniversary. So she provided history of where B2i came from. So where are we at today, 10 years later? As of September 30th, 2024, we had 257 young adults who are actively participating in the B2i program. However, in the last 10 years, we've had 1,498 young adults who has chosen to participate in the program. 89% of those currently in the Bridge to Independence program are not pregnant or parenting. We wanted to note that because you hear a lot of sad statistics about young people aging out of foster care who are pregnant or parenting. And Bridge to Independence, we're showing that it's vastly different. We have a higher percentage that are not pregnant or parenting. And 50% of the young adults' primary program eligibility is employment. So next slide. We're going to just go over a few slides with about data. This is young adults who have been served by the calendar year. As you can see, since the inception, we've been pretty consistent around the 350 range for the last several years. And so we are currently, we don't have the numbers for 2024 yet, but as of 2023, we had 354, which is pretty consistent for the last several years. Okay, next slide. B2i, there are several reasons why young adults may exit the program. They can either successfully complete B2i, which is this year so far, up until the third quarter of 2024, which was September. We had 59 young adults who successfully completed B2i. We had 4 young people who chose that B2i was not a program for them, and they decided to seek services and supports elsewhere. We had 24 for a lack of cooperation, not participating in the required elements of B2i, such as employment or education. We had a few that did not meet with their independence coordinator, which is a requirement of the program. We had a few that were unfortunately incarcerated. And we had a few that also were not able to stay in the program because we were unable to approve their housing, either because they did not allow us to seek their housing or they were living on the streets or other housing that we cannot approve due to 4E regulations. Okay, moving on to the next slide. And Sarah can help me with this. Sarah was very instrumental in the child trends evaluation. This occurred in 2019. It was involvement in B2i to reduce the negative outcomes that youth who age out of care are more likely to experience. B2i participants were more likely than their non-B2i peers to have post-secondary education, have safe and stable, affordable housing, be able to cover their monthly expenses, have adults to turn to in a crisis for a loan, and have some savings. B2i, Child Trends did meet with B2i participants individually during some town halls, and that's how they gained some of their information. They also looked at data. All reported high quality, positive relationships with their independence coordinator in progress towards their goals, and that their stipend helped them significantly to be more financially secure and focus their energies on other things such as gaining more skills through their employment or education. However, they did say that Nebraska could probably do a better job of marketing Bridge to Independence. Is there anything you want to add to that, Sarah? Okay. All right, moving on. Okay, B2i staffing. We are, our staff only focus on those young adults that are in the Bridge to Independence program. We have Bridge to Independence staff located across the state. We currently have 13 independence coordinators spread across the state. We have 2 B2i supervisors that supervise those 13 IECs. And we have the possibility of hiring 3 additional staff as probation young adults come into the program. Those staff will be hired accordingly to probation young adults coming into the program, because we do not know how many will come in and where they're going to be located. So we want to make sure our ICs are in the appropriate locations so they can serve those youth and young adults appropriately. Next slide. Okay, we have 2 supervisors. You'll be meeting Kathy Anestein here in a few minutes. Terrence Williams is a supervisor. He is located out of the Lincoln office, but he pretty much supervises Lincoln and west towards the Panhandle. So he has Val Gardner, who is in Lexington, Chris Mendoza in Kearney, Dave Bruno, Jordan Hausch, Jason Gilbreth, Rebecca Henderson, and Kylie Aldred, all in the Lincoln office. Kathy Anestein has staff that is both in Omaha and the Fremont. They cover the Eastern Service Area, which is Omaha, and then they also cover the Northern Service Area. That's Tish Kopp, who is located out of Fremont. We have Brenda Steinheider, Mindy Anderson, Melissa Pratt, Dara Battelle, and Jamie Anderson, all located in the Omaha office. Okay, next slide. Program overview and eligibility. We'll be talking about basic Bridge to Independence and eligibility. So if you want to move to the next slide. Services provided to the young adult within the Bridge to Independence program. We have 3 main components of the Bridge to Independence program. As Sarah indicated earlier, they can receive medical coverage based on Medicaid eligibility. Case management, which is our independence coordinators, they will provide young adult driven services, which the young adult basically drives where they want to go with their case management and what goals they want to focus on. There are monthly meetings with the independence coordinators. Those are in face. They can also be done in addition to those face-to-face contacts, either by email, calling, or texting, whatever the young adult is needing. We try to meet with them to meet their crises or just even talk about what's going well. We also help with securing vital document access to make sure they have their birth certificate, social security card, state ID, or driver's license to ensure that they have the documents they need so they can gain employment or get into an educational program. We also can try to connect them with community resources or any other public benefit to make sure that their basic needs are met. And there's much more. As I said, young adults will drive what they want to focus on, and we will help them pursue those goals and those dreams. There is a monthly maintenance payment that is provided to the young adult. That is the only payment they get. And then they have to budget that money accordingly. Okay, next slide. To be eligible for B2i, they have to have several components. This includes age, which is between the ages of 19 and their 21st birthday. However, if they are under the jurisdiction of a tribal court, they may come in as early as 18 because some tribal codes do in their jurisdiction at 18. So tribal young adults can come in at age 18 and remain in the program until their 21st birthday. There is an adjudication, which it's the 3A, it's the abuse and neglect. They can enter B2i if they were adopted or entered a guardianship at age 16 or older. There is also the adjudication if they happen to have a guardianship that was dissolved under the age of 19, they can enter Bridge to Independence. And then, as we are going to talk more, there will be the probation component. Eligible placement when aging out, they do have to be in out-of-home care, which means that this could be a foster home, group home, the YRTC. We do have youth that are missing at age 19. As long as they went missing from an out-of-home care, they would still qualify. So as long as they were not reunified with a parent, then they were probably more than likely considered in out-of-home care. Immigration status, which I think Sarah is going to address in detail a little bit more, they do have to have lawful permanent status in the United States. Nebraska residency, that is the young adult has to reside in the state of Nebraska. However, if in their juvenile court under the age of 19, they were placed in out of state due to an interstate compact, they are allowed to remain in that state that they were placed by through the court order or the interstate compact, or they can also move out of state if they chose to go into the military and they're stationed in another state, or they chose to go to post-secondary education, a college where they happen to have a scholarship, because we do not want them to choose between Bridge to Independence and their educational goals. Voluntary placement agreement. This is an agreement that young adults have to sign to enter into the program that is placing placement responsibilities with the Department of Health and Human Services. Keep in mind that these are young adults. We do not have legal custody over them. They are young adults. Work and education requirements, which I believe Kathy is going to go into more detail about that. There are criteria in which a young person has to fulfill to remain in the program. Approved living arrangements, that also will go into more detail later on, but they do have to live in an approved living arrangement, such as a continued in the foster home, an apartment, transitional living. But again, we'll go into more detail about that. Okay. If you want to move on, I believe Kathy Anastine is going to be talking in more detail about eligibility.
Hi, I'm Kathy Anstine. As Deanna stated, I'm one of the supervisors with the Bridge to Independence program and cover the Eastern and Northern service areas. Deanna went over some of these things, but I'll just briefly touch on them. As far as age, it's age 19 to 21, unless it is a tribal youth whose jurisdiction would have ended at age 18. Those youth can be in the program for 3 years, so they can be in from age 18 to 21. We do have one person right now that is 18 and in the program. I think we have 2 more that we're in the process of signing up as well. As Deanna stated, the adjudication, they have to have the 43-247 3A adjudication or the equivalent under tribal law, or subdivision 8, which would be those disrupted guardianships or adoptions. And then they need to be in an out-of-home placement or discharged to independent living, or it can be those youth that were placed into a subsidized adoption or guardianship after the age of 16. Next slide, please. This next slide here talks about developmental disability services. So in the beginning, we did have young people who were receiving the DD waiver, were in the program, but that was changed a few years back, that now that if there is a youth that is DD eligible and receiving the DD waiver, they're not eligible for B2i. So we've been doing a really good job, I think, of staffing all of those cases with current caseworkers to make sure that we know which route the young person's going to take, if they're going to be staying with DD services or if they're going to be coming into the Bridge to Independence program. Next slide, please. For residency, like Deanna talked about, you have to be a Nebraska resident. Some of the things that we look at for residency is just obviously if you're living in the state of Nebraska, or also could be a young adult that is going to school outside of the state of Nebraska, but maintaining their residency back within Nebraska. So they intend to return back to Nebraska. We also have had some young adults who are members of the United States Armed Services, and they might be living outside of the state of Nebraska. And as long as they are not using that state as their residence, they can continue to be in the program. And then, like Deanna said, there is sometimes we, as the HHS, will place a young person, maybe with a relative or something, in another state, and as long as that young adult remains living in that state, they can still be considered as a Nebraska resident. And same then with the tribal youth, if they're placed outside of the state by the tribal court, they would still be considered as a Nebraska resident. They do need to be a Nebraska citizen or a U.S. citizen, or have lawful presence in the United States. And I think Sarah's going to do a little bit more detailed talking about this. Take it away, Sarah.
Okay, next slide, please. Okay, yep, that's it. Okay, so yes, this does get tricky. So I'm going to go over the law of immigrant eligibility for the B2i program. And then if you have questions, as Appleseed sees it, and then if you have, questions on that afterwards or in individual cases, feel free to reach out to us. So this comes from B2i regulations that say a young person must be a citizen or have an eligible immigration status to participate in B2i. The confusing part is what immigration statuses are eligible. Because in Nebraska, we have a law that restricts immigrant access to public benefits. That is in 4-108, and essentially said, and there's some federal laws about that too. Anyway, the state law essentially says that a person has to be lawfully present to receive public benefits. And in 2020, the Nebraska Supreme Court defined lawful presence actually in the context of a B2i eligibility case. It was an Appleseed case, EM versus HHS. It said that for the purpose of receiving Nebraska public benefits, lawfully present means the immigration status categories in federal law at 8 U.S.C. 1621A, which are, so here are the categories the Supreme Court interpreted lawfully present to include. First, qualified aliens, again, as defined in federal law, that includes a number of statuses like asylees, refugees, lawful permanent residents. And then 2, non-immigrants under the Immigration and Nationality Act, which are people that are temporarily here, like students or workers on visas. And then 3, aliens paroled in the U.S. for less than a year. And that list is exhaustive. So according to our Supreme Court, to be eligible for B2i, you have to have a status in one of those 3 categories. But the B2i regs say different. They only allow for citizens and qualified aliens to be eligible. So that's one of those 3 categories, and narrower than the EM cases allowance. So there's an inconsistency there. But the takeaway, I think, is for sure citizens and qualified aliens are eligible. And then Appleseed would say that the Nebraska Supreme Court's broader definition applies, allowing also non-immigrants and parolees as well. And one more point, I guess, while we're on the immigration here, going back to the EM case for a second, since it deals with immigrant eligibility for B2i specifically. In that case, the plaintiffs had pending applications for special immigrant juvenile status, or SIJS, and they were denied entry into B2i solely for that status. Ultimately, the court, as I said, sided with the state and held that B2i is a public benefit. We were trying to say it was foster care, but a public benefit that young people need to be lawfully present to access. and that SIJS is not a lawfully present status within the federal law that they were referencing, meaning that they are ineligible. So that is tough for a lot of reasons, especially since that SIJS is the status that most youth in foster care would be eligible for. The good news is that in the end, this isn't the end, we don't think, for immigrant youth in B2I. In the EM case, the Nebraska Supreme Court said that although those youth are not eligible now, federal law does allow them to be eligible if the legislature explicitly says so in statute. So all this population needs is a law clarification, and advocates in Nebraska think that that could be possible in the future. The B2I Advisory Committee has consistently made that recommendation, that that's a population that we should expand the program to, specifically in statute, and also formed a special committee in the last year dedicated to exploring what this could look like. So stay tuned. I think that's all I have, and I'll turn it back over and again, come back later.
Great, thank you. The next slide, this slide talks about participation eligibility. So in order to be eligible in one of the categories that we have for young people, there are 4 different categories that they can sign up under. They could be enrolled in school part-time, working part-time, be in what we call a barrier program, or be incapable. And I'll talk a little bit more specific about each of those. So for the education or in school part-time, we have 6 credit hours if they're attending college. They could also be finishing their high school diploma. They could be working on their GED. So we take all of those into consideration under the school category. For working, it's simply 80 hours a month. So part-time, basically around 20 hours a week. The in-job skills program is 40 hours a month. That's our barrier program. And that can be different things like working with an employment agency. Maybe they have very specific barriers. They're in the rural area. They don't have difficulty finding a job or transportation, or maybe they have mental health issues. There's just I think that the independence coordinators do a really good job of really sorting out someone who is really struggling with getting work or keeping work or getting into school, that they really work with them on identifying what those barriers are to help them to be able to be more successful once they are employed or signed up for school. The incapable category, that's really like if a doctor writes a note for them for some reason or other that they're incapable of either working or going to school for a certain amount of time. And then they are have the opportunity to move back and forth in between all of these. So if they start off at school and they're like, yeah, this really isn't for me, I think I want to go to work, or vice versa, they can bounce back and forth between all of these different categories. And they can lapse temporarily in there as long as it's less than 30 days. And then we do ask for like their schedule for school so that we know they're enrolled, or their work schedule, or pay stubs for verification for the categories. Go ahead, next slide, please. Housing requirements, like Jana said, they do have to have an approved housing arrangement, and we're really pretty lax on that. It can be in a group home, in their own apartment. They could be living, a lot of young people still remain with their prior foster parents. They can be living in the dorm, shelter, just a lot of different housing options that they can have. We do have to approve their housing, but sometimes that can be, it might scare kids off a little bit. So we really try hard talking to them to let them know, hey, when we go in to approve your housing, we're just walking in, making sure, yeah, you're living here. There's, it's a safe place to be. The roof isn't falling in on you, and that it's an okay place for you to be. I can only think of maybe a couple housing situations that we haven't really approved. And it's been more for things like kids are trying to live in their car, or maybe camping, or if they're incarcerated, of course, that housing can't be approved either. But we're pretty, it's not as big a deal as sometimes I think young people like to make it. But and then if anytime they do change their housing, they need to let us know within 10 business days. Next slide, please.
Kathy, before you go to the next slide, I have a couple questions in the chat that I want either you or Deanna to address.
Okay.
I've been keeping track of them. So first one is, what if they live with a parent but remain a state ward at the age of 19? Do they still qualify?
That's kind of tricky. Normally, I mean, it would depend. Usually they would have to be in independent living independently with their parent, paying their parent rent. There would have to be a goal that they're at its independence, because otherwise that's really kind of looked at as reunification. So I think that would be something we'd have to look at on an individual basis. We'd have to see what the court has ordered, what efforts have been made for independence in our documentation and things like that. I don't think I can clearly answer that in just one for each. It's have to be looked at individually. What do you think, Deanna? Anything different?
I would agree. We look at those individually, really, because we have to make sure that the young person is living independently with their parent. The parent is not taking responsibility over that young person. It's more of a roof over their head, or if it's truly reunification. And again, we don't want to discourage reunification. So them moving back to the parents, maybe just because they got evicted for some reason, we couldn't find a placement during COVID when dorms were closed. They needed a place to go in an emergency. So we did make some special circumstances in that case. So those types of things.
Would it change your answer at all if the parental rights were terminated and that child lived with the parent?
Right. That would be different because there's no parental rights intact anymore. That's not legally their parent.
Okay. Let's see. Should a kiddo wait to apply until after they turn 19 or a month prior to turning 19? So basically, when's the best time for them to apply?
They can apply at any time when they're 18 and a half. We send the application into we have a online area that they can submit their application to at that time.
Okay, so you're saying, do they have to wait until they're 19 and a half, you said, or just
18 and a half?
I'm sorry, 18 and a half. Perfect. Yes. Thank you. I misunderstood. I have I think, one more to clear up. Just is a question from an attorney who has a lot of B2i kiddos. She says, my B2i young adult clients often don't contact me upon my appointment and or don't update their address and phone number. Do the independence coordinators have and share correct information for the appointed attorney with the young adult?
I think normally they do let the attorney know, and the court reports that we write will go to the attorneys. I suppose it probably is true that they don't, unless they had a really tight relationship, maybe they might stay in contact, or unless they needed something. Normally, I think that usually the appointment information comes from the court that they get appointed, but then you can always contact the independence coordinator to get information if you'd like some more detailed information about their phone number or address.
And in the training for the independence coordinators, do they encourage the kiddos to contact their attorney if the independence coordinator sees that maybe there's some barriers coming up or issues that may need to go to court to have a judge look at?
They always, if there's anything that comes up that they, have any kind of legal things, we always say, you might reach out to your ex guardian ad litem or your current B2i attorney.
Okay, and one last one before I'll let you guys go on, because I know we're going to run short of time. Are legal parents notified of their enrollment at any point?
We do not notify the legal parents of when a young person signs up for the program, no.
Okay, thanks. I'm going to let you get on with the program so we don't run out of time, and I'll still keep track of questions. Thank you.
I'll hurry. The next slide talks about the Voluntary Services and Support Agreement. This is what we refer to as the VSSA. This is our contract, the contract that the young adult signs up with Health and Human Services. So this is something that has to be signed by the youth so that, and now it will be also the youth probation. And once they're eligible and interested in the program, they sign this document. It's a pretty lengthy document, has a lot of different things that really states out specifically what their responsibilities are and what HHS responsibilities are. And I think that the independence coordinators do a really good job of specifically reading it's kind of monotonous. I'm sure some of the young adults are like, what are you doing? But they actually read each line, and there's a line there where they have to initial it to state that they heard it, they understand what they're signing. Because we don't want anybody signing something just because, hey, we said, hey, sign this. So like I said, it goes through all of the very specifics about what's expected of each party. And then the VSSA doesn't really become final until the young adult independence coordinator signs it, and then the supervisor also signs it as well. Services start within 15 days of that signature, and it also shows that HHS is responsible for ensuring that the court case gets started, that the foster care payment is started, placement and care responsibilities, and then case management responsibilities. Next slide, please.
Hey, Kathy.
Yes.
Can we jump to the probation slides? Because I'm worried about time.
Sure.
Thanks, Deanna. Hi, everyone. My name is Lindsay Meyer. I am the Juvenile Justice Reform Specialist here in the Administrative Office of Probation, and have a couple of slides to share with you all about probation's role in the Bridge to Independence program. Next slide, please. Thanks. So first, we'll talk about B2i eligibility for probation youth. So first, the youth must be adjudicated as a juvenile described in subdivision 1, 2, or 3B of section 43-247, and in a court-ordered out-of-home placement in the 6 months prior to attaining 19 years of age. So that really creates the ability for the court to have an eligibility hearing. And when the court is holding this hearing and making their finding in the 6 months prior to the youth attaining 19 and in the out-of-home placement, they would consider the following, and these are directly from the statute. So they are considering whether the juvenile is disconnected from family support that would assist the juvenile in transitioning to adulthood. They would consider whether the juvenile faces the risk of homelessness upon closure of the juvenile court case, or whether the Office of Probation Administration has made reasonable efforts to return the juvenile to the family home prior to the juvenile's 19th birthday. An important exception to note is that a youth with a current pending motion to revoke probation before the court at the time of their finding hearing would not be eligible for the Young Adult Bridge to Independence Act. So that motion to revoke probation must be disposed of prior to the finding hearing taking place for that youth to be eligible. And important to note that multiple finding hearings could take place as the court works through determining eligibility of that youth based on the statute. Next slide, please. Next, I'll talk about probation's role for B2i youth as we work to identify these. So first, here at the administrative office, we will be identifying potentially eligible youth who are 18 and a half years old and in a court-ordered out-of-home placement. And this placement could include long or short-term placements, and that youth would need to remain in that placement until their 19th birthday to remain eligible for the B2i program, but we are identifying them at 18 and a half. From there, the probation officer will then connect with the youth who are identified and provide them with a brochure about the program and discussing what's available through the B2i program. The probation officer then stays in contact, of course, with legal parties and the court to ensure that a court finding hearing and subsequent order is issued, which determines the youth's need for out-of-home placement per the statute and the sharing of information between probation and DHHS. So the court order allows that sharing of information. And then upon the court finding that order, the Administrative Office of Probation, we will notify DHHS of that finding and provide a referral to assist in that preliminary eligibility finding for the program, which is done by DHHS. From there, the probation officer will attend staffings with DHHS and continue ongoing collaboration with the B2i Independence Coordinator regarding the youth status through case progression up until that 19th birthday or termination of probation, at which point then the youth passes on to DHHS into the B2i program. Next slide, I believe, is back to Sarah.
Okay, yes. So as has been noted, there is a Nebraska Supreme Court case, an appeal pending before the Nebraska Supreme Court related to this bill. The case is State ex rel. Hilgers versus Evnen, and it is a challenge to the constitutionality of LB 50, which is a larger package of criminal justice related bills that this B2i JJ expansion was included in. So it's important to understand that LB 50 was a massive bill, over 50 sections, covered a lot of topics. The case is only challenging two parts of LB 50 that expand what types of adults are eligible for parole. So completely unrelated to the juvenile justice expansion. And in fact, all parties to that case seem to agree that the challenge sections about adults that are eligible for parole are severable from the rest of LB 50, such that everything else should be okay, including the Attorney General who brought the challenge, said that the sections were severable. The lower court agreed with that. On appeal, the appellant Secretary of State did not dispute that. However, the severability aspect is still something that technically the court will have to decide. So it doesn't seem like a disputed issue, such that the other pieces are at risk, but it still is a potential question if they would take it up sua sponte. So for now, that case is still pending before the Nebraska Supreme Court. All briefings have finished, and it's currently on the Nebraska Supreme Court's proposed call list for oral arguments the first week of January. We'll be keeping track of it, but I can speak as Appleseed with a really good legal analysis, but I don't work for the judicial branch. But our take is that the B2i expansion is not at risk, and that for young people, the program is currently law and should start on January 1st. We would encourage attorneys to ask courts for the findings necessary. But again, we acknowledge that probation and others under the judicial branch are in a difficult position due to the appeal. I'll pass it back for you to share where you all are at with that.
Yeah, thanks, Sarah. So, as Sarah mentioned, upon a final decision of the appeal, when that happens, we will begin to identify youth and provide those information brochures, etc. In the meantime, however, we are looking and identifying youth who may potentially be eligible, and really looking and relying on the court and parties to the youth's case to move forward and on their own motion and allow that judicial discretion in terms of determining eligibility and that subsequent order that of course, upon an order from the court, we would proceed with following through with that.
Due to sake of time, I'm not going to go through these, but one thing that I really do want to emphasize the most, especially when we talk about the probation population, is the only way they can get into the bridge to independence is through that court order and that wording. So if the wording is not there and we have a young adult who ages out of probation, there is no way for them to come into B2i. So if you have a young adult, this is something for the team to consider. If you have a youth under the age of 19 in probation and out of home care who might meet the criteria, and the youth not sure if they want to enter B2i, That's okay. Even getting that wording in the order does not require them to enter B2I because B2I is voluntary. But after the age of 19, if they want to, and if they see the need that, yeah, maybe B2I is something I want to try, they have the avenue. You've kept that door open. And that's really what that is keeping the door open for these young people, because B2I is a solid foundation that can help them transition into adulthood. We have only 5 minutes. I want to cut it at that. I'm not even, because I see there's a lot of questions in the chat. So I don't know if we want to start addressing how we're going to address those questions. But again, DHHS is ready to take probation youth and young adults on as effective January 1. We are excited about the population. So we're up and ready.
Okay, we've actually answered most of the questions in the chat. There is one that I missed. Would B2I for juvenile justice youth apply to a youth adjudicated under 247 3 sub C?
Can you hear me? Sorry, I was having trouble with my mute button.
I can hear you now.
So I would say for the juvenile justice youth, it's the subsections that we mentioned before, the 1 and 2. And so I would say no, but would defer to Sarah if she has a different response.
So I believe the PowerPoint's going to be going out, and the last slide is truly just how to get a hold of the B2I. It has the supervisor's emails. It has my email. It also has our administration prevention administrator, Camus Holder, on here. So if you have any other questions, you can reach out. Also reach out to probation, Lindsay Meyer, and anybody in the administrative office, because they would be more than happy to also help you navigate the new population for probation.
There is a question in the chat from Jennifer Carter that I think is a good clarification. Maybe.
I think so too. Jennifer asked, probation will not refer youth to the B2I program under Nebraska Supreme Court rules, ? But if there is a court order finding a probation youth eligible for B2I prior to the Supreme Court case decision, I think you mean, they'll work with youth on B2I. Basically, Jennifer, obviously probation will follow a valid court order. So if a judge puts the language in saying probation needs to refer that youth to HHS, they will certainly do that. But until we do have that Supreme Court ruling, probation won't be giving the brochures out. And just so you know, go ahead.
Oh, I was just going to say, so we encourage attorneys to be, talking to their clients and raising the issue if they can.
Exactly. And then just requesting the judge put that language into the court order in that 6 months prior to the kiddo aging out, so we don't miss anybody out there.
Yes, I would just underscore what everyone said so far, and I appreciate that summary of our position and the importance of the attorney support and the court support in obtaining those court orders.
And Heather, you asked, can a probation youth apply themselves online without a referral? Remember, for a probation youth, they have to fall into that eligibility requirement. But the most important part too is they have to have the language in the court order. So on their own, not really. If that language is in the court order, then let's say they're 20 and they decide they want to do B2I, then yes, HHS will definitely help them out and see if they kind of check all the other boxes of eligibility requirements.
And it's 6 months prior to turning 19, and it goes into effect January 1st. So we're hoping that this has been starting to happen and is happening now.
Reggie asked, what is the specific language that must be in the court order 6 months to aging out? Basically, Reggie, it's the language directly from the statute that I'm kind of paraphrasing, that the kiddo, can't go home, that it would not be in their best interest to go home. I think it's the child welfare language. In that probation made reasonable attempt do you have it up? There we go. That the A, B, and C, just that type of language. And just so you know, we have done this presentation to the judges as well. So they're aware of this. They're aware of the issue with the appeal. A lot of the judges are going to be putting language in. You might have already been in front of one that has. Part of this is going to be a judicial decision too, how they feel about the appeal. But again, we don't want any kiddos to fall through the cracks. So I'm encouraging attorneys to make sure they're asking judges within that, that 6 months of your kiddo aging out to get this language in.
Deanna,
So
it's a contrary to the welfare finding, correct?
Correct.
Yes.
All right. I think we've addressed all the. Oh, wait. For a youth who isn't adopted yet, but will be turning 16, how do they apply for B2i?
They will be provided information, or their adoptive parents will also be provided information when they are finalizing their adoption. We also send out notices to the young person up until their 19th birthday, and they can apply. And then we on the website or the different areas on how to apply, and then we can reach out to them.
I was going to say kind of what you said, Deanna. There's a link on the DHHS website on how to apply and what the eligibility is for B2i for kiddos.
Yep.
I just wanted to, for those still on the webinar, I have uploaded the presentation slides to the chat a few times, but I didn't want them to get lost in all the questions and comments.
Thanks, Tracy. Well, we are past our time. Thank you so much for my experts. I appreciate your time in helping us kind of give B2i and the expansion to everybody out there. Thank all the attendees for coming, and have a good rest of your day.